Thanks, everyone. I very much am honored to have this privilege to address you all. Those of you who know me will be not surprised by my style of presentation. I much prefer this to be a discussion facilitated by myself as opposed to me lecturing you. So as and when, from my perspective, you've got questions, by all means ask them as you go along and we'll make a plan. It might be inconsistent with how these sessions are run, but I'd much prefer to have a lively debate as opposed to one of lecturing. Just to take a few backward steps, those of you in the room who know about competition and payment, certainly in the South African environment, will think primarily banking inquiry, will think interchange fees, will think presumably allegations of cartels and price fixing, etc. Those are not things I want to talk about today. I think banking inquiry has been talked to a death. Those of us have spent many years implementing, discussing it, and there's many of you in the room I can see who have personally sacrificed a lot of time on that and got the war wounds to prove it. Interchange fees, again, that's done and dusted, I think, from a South African perspective. I think the question about interchange fees going forward is, the so what? What's the consequence of regulatory intervention, and is it optimal, etc.? But that's the same debate that is being had in many a jurisdiction. And there may be, of course, ongoing developments going forward. What I really want to talk about today is the more kind of nuanced questions of collaboration. So clearly there are things that your compliance departments, your legal departments have told you not to talk about, and those are relatively obvious things. And again, this is not a compliance program. This is not me telling you do's and don'ts. What I wanted to talk to you about is what are the perimeters of the legitimate conversations that one can have in an industry payment environment, such as PASA, but not necessarily PASA, and what are the limits of those of collaboration, hence the discussion topic, the boundaries of collaboration. Now, intrinsically, payments, in my world at least, intrinsically is linked to collaboration. You need to pay somebody, that involves some element of collaboration. But what I want to look at is, given the relative dearth of developments in South Africa, is to look, and given the theme, of course, of this conference, the international aspects of it, is to look at international developments and to carry those across to South Africa and ask ourselves a question in terms of what are the unintended consequences and are the things that we do potentially subject to challenge. Now, I'm not suggesting you guys are going to all go to jail because now cartel conduct under the Criminal Competition Act is criminal conduct. I'm not saying that. I'm talking about the nuanced type of conduct that potentially is well-intended, but has those unintended consequences of marginalizing different business models. And to follow through, competition policy is only one policy objective. Of course, the management of the payment system is another. I think from my perspective, I'm certainly not saying that competition law takes precedent over everything, but you need to be, of course, sensitive to those risks and marry those alongside other objectives. When I look at international developments, I certainly, despite my accent, I'm not a colonialist, and I don't want to say this happens in the UK, hence we must apply it here. What I want to suggest is we need to probe developments in other jurisdictions and understand the read across, as opposed to automatically doing a copy and paste, which is often the case. So when I've looked at developments over the last few years, these are the aspects that I found of interest and I think have some resonance to the MPS. I'm going to be talking about these developments, but I want to be applying these developments to the current landscape. And there, I'm kind of dependent on your insight and your input from the actual discussions you're having, whether in your PCH or in your PSSF or whatever, and understanding what is the relevance of these discussions. Needless to say, and I should have said this up front, I'm not here to represent anybody's views, let alone my firm or my own views. I'm here to prompt a discussion. So don't mistake what I'm saying for my own personal views and lynch me for them. The four issues that I want to talk about is standardization, market infrastructure, sunsetting a payment product, and interoperability. Now, these are all topics that I found of interest when I've looked at the international jurisprudence, if you want, of payment competition interface. And we can go through those and debate, and there may be others that you want to talk about. Standardization. Given, as mentioned in my introduction from my sins, when I was working in London and Brussels, I used to advise the European Payments Council, which those of you who are familiar with it is not say a trade association, because I think that does it a disservice in the same way as calling PASA a trade association. It is an industry management association in terms of payments, which is dealing with harmonization of payments across SEPA, which is obviously the single euro payments area. Now, there was an investigation in 2011 linked to the e-payments framework. As you may know, in SEPA, there was a number of schemes which we launched, one being it's a direct debit, which is a debit order scheme, and a credit transfer scheme. These were pan-European schemes. These have never been done before, and you guys probably are much more familiar with it than me. Now, what they tried to do in this case was to have an online payments framework, whereas on the basis of their credit transfer, which is obviously their EFT credit equivalent, to enable online payments to be paid using this scheme. Now, you had this organization called Sofort. I don't know how you pronounce it. It's German, and I'm not German, so I'm going to hazard a guess. And they're involved in direct transfer services. When I've looked at their kind of business model, they're very much positioned as a wallet of sorts. You enter your details, or you obviously register with this organization, with this entity, and you put in your credentials for your online banking, and you essentially pay using this wallet for online services, and they essentially interact with your online banking in the background. So you may have online banking with a number of banks, and you put in your details, and as and then you want to use specific pockets of value, you can use them. Now, the framework was drafted in a way which was premised on your typical online banking. Now, I'm not suggesting that the members of the EPC had any intentions to exclude these different types of customer interaction, and I think this is a classic case of where competitive dynamics are evolving. Nobody would have necessarily seen this kind of piece of tech years ago as a competitor to banks. But of course, as banks enlarge in their value proposition and want to go on to these value-added services, and we'll talk about this in a second, there's certainly a competitor interface between what we see as your typical, obviously, payment providers to these, obviously, these payment system providers, as they're called as a whole. Essentially, the European Commission intervened and essentially forced the EPC to withdraw their framework. Now, what's interesting in this case, illustration of another point, is you've got the regulator, the competition regulator, saying you can't do this, and yet you've got other regulators such as the European Central Bank, DG Internal Market, etc., who are pushing very strongly for this type of harmonization. So this is, for me, the classic debate of being caught between a rock and a hard place. Something that those of you in the banking inquiry will be very familiar with, where your competition regulator is doing something and your sector regulator is telling you don't do it, or in fact do something opposite. This is something which of particular resonance and something which is typical for a regulated sector. This same entity, again, complained to the German competition authority, who recently, I think in July this year, found that the German banking associations had been found guilty of contravening German competition law, because they had agreed by means of the banking associations to have general terms of conditions which prevented their customers, i.e. their online banking customers, to use the services of the same entity. So they were prevented for security purposes from putting in their details, their PIN and whatever they needed to validate their online entry, or the basic authorization to use their online banking going forward. Essentially, what the German Competition Authority, which has taken quite a lot of stance on payment issues, said that they could not see why on security basis you needed to prevent your customers from intervening, from using these services. These services were complementary, and in fact, these services were a response to customer needs in the first place. Online retailers also wanted those things. Certainly, from our space, I'm aware of some direct transfer services. But again, it shows the illustration of where classically we think online payments is your card-based payments. Here, they're pushing your EFT credit, essentially, is preferred payment of choice. Which obviously has implications for the merchant as well as the consumer. What they looked at in this case was saying, actually banks, and this has, I think, particular resonance if you think back a few years ago to that 22/7 debate, when a lot of banks jumped up and down saying you can't possibly use our online banking as a almost data input into this value proposition. does pose a different question, of course. By allowing them, are you facilitating a competitive interaction of a competitor because they are becoming competitors? There's things you need to think about in that case. In this case, you've got a trade association who are clearly taking decisions, a banking association taking decisions that we will not accept this as a German banking industry. In South Africa, of course, we haven't had that, but it begs the question, what happens on a one-on-one case? If 22/7, I know, for example, I shouldn't cite a specific entity. Let's say another entity wanted to go to a bank and say, we want access. On what terms should you grant access? Should there be a certification process? How do you deal with issues of liability? Those are things all in the background. I think turning to the relevance of NPS, I think certainly what I would see there is kind of an interface between new services, developments and offerings, and your traditional services. Just because you're not a bank doesn't make you not a competitor. Certainly, we have a fairly typical view of what we see as retail banking. Does that include personal finance management? Does that include EPPP? Those type of things. Those introduce quite a lot of tech and different offerings, which certainly muddles the water in competitive dynamics. Classically, classic people would say to me, this whole bank, non-bank regulatory dichotomy is anti-competitive. Well, to be honest, it's not really a matter of competition law. That's a matter of regulatory policy. So that's really not an issue for us to consider as competition lawyers. That's something that we ought to lobby about if people feel strongly about it. Certainly, the competing interests amongst regulatory bodies, when you've got a sector regulator versus the competition authorities, that's something that we need to look at. What I also wanted to talk about is unintended consequence of technical standardization. We think of tech in a very kind of snapshot perspective. I'm thinking primarily, hypothetically, let's see in the AC debate, we've got a fantastic piece of kit which does authentication, for example. At this stage, it's maybe the best piece of kit. Maybe in 2 years' time, it's not. If we've built the product designed intrinsically about one piece of technology, essentially you've granted somebody a monopoly. Is that good for competition or not? Simply because the banks are in the clear from a competition perspective doesn't mean it's good for competition. Those are things I just wanted to put in there as kind of discussion, saying we mustn't just look at competition, I think, in banking, but also in related services. Again, I'm talking hypothetical. Market infrastructure. I noticed time is going by and I've got a lot to cover. Market infrastructure. Very recently, earlier this year, payment system regulator in the UK, who has a competition mandate, said essentially that banks, the fact that a very small number of banks own the market infrastructure in the UK has a dampening effect on competition. Now, when they looked at this, it's quite interesting that they had a particular resonance to the NPS debate. Firstly, it said the fact that people see their ACH essentially as a not-for-profit means that they don't actively seek better deals elsewhere. The fact that they see it purely for security terms, in terms of resilience or risk over competition, also meant that they didn't look elsewhere for better deals in terms of those infrastructure services. And then there was this whole confusion they found between a shareholder against a user debate. Now, you don't need to be a genius in terms of where I'm going with this. This clearly has discussions that we've always had in South Africa in terms of ownership of Banksurf. And again, I'm not saying anything bad about Banksurf. I'm just putting it out there that this has a clearly discussion that has a resonance for whether we should, as banks, be owning a stake in infrastructure. What are the unintended consequences of that? Those of you obviously been following developments, you will have seen that MasterCard recently announced its acquisition of Link, which again, having a for-profit ACH monopolist also has potentially unintended consequences as well, which we can debate. I'm just going to skip this slide. Suffice to say that procurement decisions are often things that we don't think about in terms of which clearing provider we should use or not, but in many cases, where there has been choice, for limitations, joint decisions has been criticized. Why is it that when we have a new product at Parser, a new payment product, we ought to have to use Banksurf instead of somebody else? That's a joint decision. What are the unintended consequences of that? That's, albeit in an adjacent market, credit default swaps, clearing is clearing ultimately, in my view. And in different investigations, joint decisions have been criticized by competition authorities. We just need to think that through, and the things that what we take as a given in our context, we need to start questioning, say, what are the unintended consequences? Pretty much that is NPS relevance, which I've already spoken about. So, what is the optimal model from a competition perspective of ACHs in South Africa? And again, this is not a novel question. This is a question that we've been posing ourselves for many years. a particular favorite of mine, sunsetting a payment product. Now, those of you, of course, around for a few years ago, of course, were sensitive to a huge political debate and all the charity uproar and the old age pensioners uproar in the UK when they said, let's possibly sunset checks in the UK. So it's clear that sunsetting a payment product is quite a controversial topic, certainly from a political perspective. It also one that necessarily has risks from a competition perspective. Now, you've got this case, which I found, a 2006 case, so not terribly recent, but again, useful precedent in Slovenia, where essentially they had this product where, in my views, in my paraphrasing, it was like an EFT, it was a standing order at POS. So basically, at POS, you would initiate a standing order, which in my world is EFT credit on that perspective. So they decided bilaterally to sunset that product and introduce a new product, bank credit. But what they did, again, to a political perspective, wasn't particularly successful because the new product was far more expensive than the new product. You needed insurance, you needed additional costs. So a lot of people complained about it. And there was, in the view of a competition authority, still a residual consumer need for the old product. And hence, a multilateral decision to sunset a product was deemed to be anti-competitive. Again, you should be thinking check exit. Is there still a residual customer need? What is the substitute for that? And how does one deal with that? I'm not saying these are impossible questions, but these are questions I'm sure you've been asking yourself. In terms of sunsetting is one aspect of clearly the decision to switch off, but steps taken to migrate as well. There was a case in France, I'm not going to go into the detail for the sake of time, in 2010, where you've got the French Competition Authority intervening in a case where, because of check migration or digital migration of checks, essentially check truncation if you want, banks had found that they had lost a significant amount of interest revenue because obviously it was being booked at different times. They had apparently multilaterally agreed to introduce fees and raise fees to compensate for the lack of income on that perspective. So it's not just your multilateral decision to exit a product, it's what you do as part of your migration strategy, and clearly check truncation is part of a migration strategy for checks in terms of elimination of costs, which is often a cost mitigation strategy, of course. In terms of relevance, I mean, as I've mentioned, check exit is something clearly on the which ought to be thought about. Migration plans as well. What I always think about is what is the necessary and intrinsic coordination that competitors ought to have in terms of new payment products. To what extent should competitors agree that this ought to have this product, this feature? Well, let's imagine a new product. Should this be P2P, for example? Should cards, for example, have a P2P function? That's a competitive question, ultimately, because it deals with competition between payment streams. There may be an operator out there who has a particular business model. These are questions which are not neutral to competition. I'm not saying competition takes precedent over other objectives, such as an orderly payment system, but these are things we can't ignore the competitive dynamics of these. Intrinsically, when we have a new payment product, when I say new payment product, I mean an industry payment product, people always talk about interchange fee, and you can't almost seemingly introduce a product without an interchange fee, because that would be blasphemous, of course. A joke. Anyway, broader implications for payment product management, even issues like item limits. Item limits are not neutral to competition. Now, one has to be only a witness to the discussions between what ADO, NADO, and EFT debit, what are their item limits, to understand the competitive dynamics of those. That's not to say that decisions relating to item limits are anti-competitive, but one has to be very sensitive to unintended consequences of this. Even, God forbid, payroll deductions is a very sensitive competitive topic for those who have built their business model, rightly or wrongly, on payroll deduction. Let's not go there now. What I found interesting was this 2011 German case, where in Germany you have a card-based debit order scheme. So basically you swipe and you create a debit order. Now, there was a rule at the time that was introduced in Germany to say that you had to have certain information in your mandate in terms of designation of your user, which was the name of your user and address of your user. Now, what this debit order scheme said was this is anti-competitive because our debit order scheme functions by card. We don't have those details on our mag stripe. Hence, you're excluding us. Ultimately, those rules were amended, but the point being, of course, we don't have such debit orders here, but the point is even technical standards have an implication for competition when there's a broader context. And what is that broader context? Depends on your business model on that perspective. Generally, there's issues about payment scheme management. Never is it a neutral discussion. There's been cases in other jurisdictions where people have taken payment scheme, when I say payment scheme, it's equivalent of our PCH, decisions, which are obviously competitors around the table. There's, people are quick to make the allegation, of course, you're going to have a vested interest in taking them in a certain way. One has to be, at even a technical level, be very sensitive to those risks. Interoperability is my kind of last topic, and I'm hoping I'm okay for time. 5 minutes? Okay. Interoperability is, of course, something which is very familiar to all of you around this room. For me, interoperability, clearly there's cases where you want to force interoperability, especially on dominant provider. In this case, there's a Swiss acquirer who had a technology side to him who had essentially the IP for the DCC, the dynamic currency conversion, and was keeping it to themselves. They were not licensed in other acquirers. So there was a case, for example, where you would force interoperability, and you can see pro-competitive. But my question for the audience is more, when is interoperability necessarily lead into not anti-competitive situations, but sub-competitive situations. So when does interoperability become a point of moving at the lowest common denominator, this closed-loop, open-loop debate? If one had a good idea for a payment system, why should one need to work in tandem to launch a product at a PCH level? This constant need for collaboration can actually hold back developments. That, of course, is married next to the process of having some form of orderly regulation of this. But again, it's not neutral to competition. One must think very carefully about how one implements the need for interoperability and at what stage. Is it simply after the nurturing stage? Often you would allow people in other industries to develop and then seek to be interoperable thereafter, because it at least encourages innovation. But again, that's a debate, and I understand we need to look at it from a payments regulatory perspective as a whole. The classic case in South Africa, and I presume the debate is still ongoing, as long as I'm here, I'm sure, is money transfers and interoperability on money transfers, and how does one make money transfers interoperable, or do you need to? Is it competitive? Is it anti-competitive? Isn't it interoperable already because ultimately it's cash, it's fungible, or you're looking at is sharing of infrastructure? Those type of things, there's lots of aspects to think about that, but one has to be careful in terms of imposing strict requirements, because that can indeed dampen, especially in the context of PASA, when you've got competitors around the table. Are you holding and intentionally holding back your competitors? One needs to be very careful about that. And again, I'm not pointing fingers, I'm just raising themes for you to discuss. So unfortunately, from a summary perspective, I haven't given you a clear do's and don'ts. So if that was my mission, I failed. But certainly what I wanted to highlight is unintended consequences of payments collaboration are quite profound, and you need to look at it at multiple levels. And well-intentions will only take you so far. One needs to really dissect what's really happening in a case and look at potentially international developments. I find personally in South Africa, we had the banking inquiry, which is a big payments intervention from a competition perspective. Then you have the bank serve EMID nomad debate, which was primarily about access, etc., from my view. What I'm saying is a whole lot more nuance that needs to be probed, and it has a sensitivity to from a competition perspective for the optimal development of NPS as a whole. Obviously, the NPS has its own objectives, one of them being obviously a competitive landscape, and one needs to be very careful in terms of how we kind of seek to fulfill multiple objectives. So given the lack of questions, I'm happy to have questions now.
I wish this was a plenary session. I think it's one of the most important topics at the conference. I wanted to highlight a point you made about the side effects of technical standards and ask you what your thoughts are around how to decouple the development of the technical standards from the competitiveness or the market forces that come later. so I'm involved in open standards bodies where the development of standards is completely done in the open. And to sit at the table, anyone's able to sit at that table and participate in the conversation. There's dynamics and politics involved, but don't you think that a lot of the issues with technical standards creating anti-competitive or collusive sort of market dynamics come from the actual process that was taken to develop those standards, and that a more open process or the ability for anyone to participate in that process would help to decouple that a little bit?
Yeah, certainly I can see where you're coming from. When you look at the case law in relating to standards as a whole and IP, I think one has to incentivize, as always, the investment which is necessary for IP. But in this context, when you've got potentially products or product decisions which potentially could cement people's positions and not drafted in a way, and I'm not criticizing the AC debate at all, I'm not close enough to that, but I'm just saying hypothetically, one has to draft it in a way that allows reconsideration of multiple participants based on common standards, as opposed to it being premised on a single provider, because not necessarily is that going to be in the interest of all stakeholders going forward. So I would definitely look at more open, and that's your classic competitive environment in the IP space. And certainly realize that you are only looking at a snapshot now. What happens 5 years' time? Hopefully this product is longer than 5 years, so you have to already foresee the future. You have to draft it in a way that allows other participants to seamlessly come in, which is, again, to your point, non-proprietary standards, open standards. So that would be more conducive to a competitive landscape.
I think the design of the technical standards is also important, because if you're designing to get interoperability through a platform or through a provider, that's a mistake from the beginning. The design needs to be, how do we get interoperability through an open standard so that anybody can be the provider? And I think often we're just in this mindset that, okay, well, the way to solve this is we pick somebody to be the PCH, and that's how interoperability is going to work. Everyone's going to connect to them. And theoretically, they can have competition, but the way things are developed or architected makes that close to impossible. So ultimately, you end up in this locked-in environment anyway.
Yeah. Certainly, you don't want to create gatekeepers. And if it's necessary partners at one point, even with common standards, you would argue traditionally from a competition analysis that is not conducive to competition, for sure. Equally, you would look at interoperability between infrastructure providers as well. The classic case, obviously, in Europe, where you can plug into one infrastructure provider to gain access to another. Obviously, we're dealing with a different economy on this side and different providers. But one shouldn't assume that we will always not have competition in relation to infrastructure as well.
That's the role of the regulator, though, right? Be the benevolent dictator in that process. Make sure that the participants are treating competition as a priority ultimately.
Yeah. Also, market dynamics when there's a need for it. Certainly, the UK case says there's not going to be a need for it if people have got a vested interest in the status quo. Certainly, if you open up the status quo and take away this vested interest, people start taking a different decision in terms of what infrastructure providers to use going forward.
A disclaimer, this is not Standard Bank's view at all, it's my personal view or thought. With the changes that are happening in PASA, and I don't know if you've read through the recommendation from the SARB, you're going to have representation by the to-be-established Prudential Authority and the Financial Sector Conduct Authority as well.
Yeah.
In order to avoid some of these competition concerns that perennially affect PASA and its progress on some matters, what about a concurrent jurisdiction agreement akin to that which the Competition Commission has with ICASA, something along those lines? And I see you made a mention that the newly revised UK Payments Association has got competition mandate.
So, concurrency is a situation where you obviously got multiple, just for everybody's benefit, regulators with the same competition mandates. So, similar competition mandates. I think ICASA is a slightly different example because they've got different interests. One is forward-looking as opposed to one is backward-looking, and they've got different situations, which is your classic environment in concurrency. Do I think that concurrency would help in this case? These questions are not currently before the Competition Commission. I think there's in other jurisdictions a lot more sensitivity. In the UK, for example, and they've looked traditionally since the Krumschak report and before then to see what is the importance of competition in payments. So the relationship between, certainly in the banking inquiry, that was an issue in terms of concurrency or interrelationship between regulators. But what I would see is much more the nuance of the individuals and the member participants being a lot more sensitive to having their own consciousness in terms of competition. If these issues were going to a competition commission currently and being inaccurate or suboptimally handled, then I could see concurrency dealing with that. My view is just because we've got different priorities in South Africa from a competition enforcement and we haven't had that many complaints on the payment side, these are not even going to a regulator in the first place, which is good, I guess. Is it optimal for MPS? Maybe not. If there was more enforcement, then maybe you would need to look at concurrency. You would definitely need to look at greater coordination because there's a lot of expertise, obviously, in the SARB and the Competition Commission. Those who did get expertise relating to a banking inquiry have now left. But that's not holding us back at the moment. I think generally just more of a debate in terms of what is competition and broadening it and not having a non-dogmatic view of what competition is. Not assuming, for example, a card can only be a merchant payment device. You know, why should a card be that? Why shouldn't it be a P2P payment? Those are things which are saying, of course it can't, because then it would erode my credit in my check account base. Well, that's competition for you. Is that a right or wrong decision? I'm not suggesting either way, but those are discussions that you need quite vigorous discussions. I think competition, sometimes people are very scared of competition, using it because they think, oh, we're going to go to jail for discussing it, and we've gone too close to a line. I think one needs to be very sensitive to the impact of competition to debate it, and not use it as a taboo subject that, oh, we have to stop the discussion because it touches upon the word competition. One has to really unpack that and have discussions, obviously prudent discussions, but still has to understand what the competitive discussions, and a lot of discussions, industry discussions, it's the elephant in the room, for example, and people don't really engage with that discussion. And one needs to. Obviously, there's payment principles, and one needs to look at neutrality of payments versus competition, and there's obviously a variance balancing, but you need to embrace the impact of competition as part of your decision-making process. Eventually, I think, given the stage, you will need to look at concurrency, but I don't see that as where we are at the moment.
Thanks. Any more questions for Mark? Mark, thank you very much.
Cheers.
And just as